Is it indicating that it's recording on your side? There we go. Okay, fantastic. It only came, it was quite delayed on my side. Okay, so we'll kick off this morning then with the corrections and amendments to patent specifications and patents. We'll jump right into section 51 of the Act. Section 51A of the Act authorizes the registrar or the commissioner. So if a matter is before the court, the commissioner is also authorized to allow a correction of any clerical error or error in translation in any patent application for a patent or document lodged in pursuance of such an application or in the register. Then looking at section 51 subsection B, it also allows for the amendment otherwise of any document for the amending of which no express provision is made in the Act. So that's quite a blanket provision to allow for any amendment where there's no specific provision made for in the Act. But if we then turn back to section 51A, you'll see that it provides for two forms of corrections in this provision, either for a clerical error or an error in translation. So an error in translation will generally occur if a patent specification was filed in Japanese, for instance, abroad, and is translated into English for a South African application. And during that translation, there may have been an error in that translation that took place, which isn't, necessarily the correct wording for the specification. In that instance, you would then rely on section 51A to lodge an application to correct that error that was made during the translation process. Then it also provides for the translation, or the correction rather, of a clerical error. Now, a clerical error in South Africa is not an obvious error. A lot of the times when you're dealing with associates abroad, we'll inquire what type of error it is so that we can depend or rely on the correct provision when making the application to the Registrar of Patents. And they'll say, well, it's an error that was obvious to somebody skilled in the art. But that is something entirely different to a clerical error. A clerical error, as you can see, has been the subject of much debate in our courts. And the one case that dealt with this was the Macaulay Corporation versus Brickcorp precast case, where the judge held that it's a careless error because it is unintentional and in his view is a clerical error. So he's basically saying if it's a careless error that was unintentional, then it would be considered a clerical error. He then goes further to say it would still be a clerical error if the error was inadvertently made in an earlier draft and was then unintentionally transferred to a later draft. So this is something where you've perhaps made a typographical error in your specification. It wasn't an intentional error, and it was just made out of carelessness. In that case, they would then consider that to be a clerical error. Then there was a further case that dealt with a clerical error. This is the case of Hokuriku Pharmaceuticals versus Supplementary. And yeah, the court held that a clerical error occurs where a person, either of his own volition or under the instructions of another, intends to write something and by inadvertence omits to write it or writes something different. If I recall correctly, the facts about this case was that the person that prepared this application for the patent forgot to include one of the inventors in the application. So the inventor should have been listed as an inventor, but when preparing the application, the secretary never typed in this inventor's name. And you can see that this does deal with this, where by inadvertence, something was omitted from the application or the specification. And it could also, as it states in the bullets below, that it could be out of sheer ignorance. An error made out of sheer ignorance would then be also considered a clerical error. Then lastly was the Pfizer versus Supplementary again case. yeah, there was an error in the claim, and it was also held to be a mindless error that was made through inadvertence. And yeah, the court said that it fell solely within the dictum that was found in the Macaulay case. So then just to conclude, in order to be considered a clerical error, it must be an error that is made carelessly or inadvertently made in writing or copying, or must be an error in a mechanical process. So again, where you are copying from a previous draft, you're incorrectly copying over what should have been there, or you are copying a mistake in the previous draft into the new patent specification, that would also be considered a clerical error. Jan Gerard, did you have a question? You disappeared again.
Sorry, no, it was an accident, sorry.
Okay, fantastic. Clerical errors arise very often in practice. As I mentioned with the Hokuriku case, in that case, where an inventor was omitted inadvertently, unintentionally, by the secretary that prepared the application, that often happens in practice, and I often deal with these with some of my clients, where after the application's been filed, they will come back to me and ask, please, can you add this inventor to the application? Well, it's not merely as straightforward as just adding the inventor to the application. I need to understand the reasons behind that, because was that omission actually a clerical error or not? And in most cases, it does transpire that it wasn't necessarily a clerical error where an inventor was omitted. It may only later on transpire when they're doing a inventorship analysis, that it comes to light that somebody should have actually been listed as an inventor. So you can see that's not something that was unintentional. They weren't actually aware of that inventor. And in that case, we would then rely on the Section 51B provision, where an amendment otherwise of any document. So I amend the application document to include that inventor. And just out of an abundance of caution, in my applications, I generally provide the reasons as to why that inventor was omitted from an application. But in the instance of Hokuriku, where it was merely a mechanical process where the secretary omitted to include that inventor that should have been omitted and it was an unintentional error, then you would rely on Section 51A, because that would then be considered a clerical error. Nomondo, you have a question?
Good morning. Hi. I just wanted to know what the term mechanical process means.
So that's generally in typing or photocopying, or where you're copying from one draft over to another draft. So something that's purely mechanical, there's no actual thought process taking place.
Okay, thank you.
Pleasure. And you must remember the issue of inventorship in South Africa is a very important issue, because once again, the Form P3 attests to who the inventors are. So if you ever have a look at the Form P3, the inventors are all listed on that declaration. And in the declaration, there's a specific paragraph that reads, the inventors or the persons named above are the inventors in respect of this invention. So if you are declaring to that and you have omitted an inventor, then it is possible to revoke the patent on the basis that there is a material misrepresentation that hasn't been remedied by the applicant or the patentee. The question that also arises is, what do you do in practice where a Form P3 has been signed and lodged at the patent office, and after you've lodged that declaration, the applicant informs you that we forgot to add an inventor, we need to add another inventor. Then you're possibly sitting with an untrue declaration at the patent office, and it creates a bit of a tricky situation as to how to remedy that. But again, something that is up for debate in practice. I don't know if anyone has comments that is in practice that wants to add to that. Okay, Nomondo, do you still have a question, or is it that old hand? Old hand.
Yeah, sorry.
No problem. Okay, any other questions that anyone might have regarding a clerical error or any other amendment for which no provision is made? Okay, fantastic. So then we'll move on to section 51. Now, the Patents Act makes provision for 4 additional types of amendments that can take place. And these are the amendments of the provisional application, the amendments of the patent application prior to grant. So that will be where the application is pending and before the acceptance has been published in the patent journal. Then the amendment of a patent after grant, and then an amendment of the patent during the course of legal proceedings. So this is when a matter is being heard before the Commission of Patents and the patentee wishes to make an amendment to overcome any invalidity in the patent that can be done during the course of legal proceedings. That's not really something that we'll go into much detail on for the purposes of this workshop, though. Now, these are the types of amendments that you would make in most cases to the specification, where there needs to be some adjustment to the specification and the claims therein. But if we have a look at section 51 and regulations 52 and 53, they tell us how we need to go about making this application for an amendment. It says that in an application for an amendment, it is necessary to set out the nature of the amendments and to provide full reasons for any amendment made. Okay, so these are very important provisions to take note of. So how do we go about setting out the nature of the amendments? Well, that's basically your track changes that you would use in Microsoft Word. So where you would show any deletions to the text. So if you are deleting a paragraph in the text, you would strike that out, and any inclusion you would then underline in the text. Look, the regulation doesn't say that is how it should be done, but that is how it's done in practice. It's basically by making use of the track changes in Microsoft Word to show those changes by setting out the nature to the amendment. And that provides any person that accesses that file one day to then see what the actual amendments were to the specification, that they can easily ascertain what amendments were made. Then you also need to provide the full reasons for any amendment made. Now, you'll recall that in most cases when an application is filed in South Africa, there is a corresponding application in another jurisdiction where examination might be taking place. Or if not, there's an IPRP that was issued during the international phase of the PCT, where some objections were raised, and the applicant then wishes to overcome those objections. So that would be a valid reason to include that, there was a counterpart application with examination where it was said that claim 1 lacked novelty, and this application is amended to overcome that objection by including a novel integer into the claim. That's just an example off the top of my head, but is something that is quite often used as a reason. Then also, considering various amendments that are required in terms of South African law. As you'll remember from yesterday, I said that method of treatment claims are allowable in the United States, whereas in South Africa, those claims are not permissible in South Africa. So the specification and claims would have to be amended to bring those claims into an allowable format for South Africa. And that would then again be a valid reason to include in your application for the amendment. And it has to be the true and correct reasons. You can't thumbsucker reason. You actually have to validly say why you are making that amendment. And this is the case for any amendment that's made in terms of section 51, where you are required to then set out the nature of the amendments and to provide the full reasons. If we have a look at section 51.5, again, not something that I'm going to go into too much detail in, but it basically only makes provision for the amendment of the specification where there's a mistake or an obvious mistake. And that is the only allowable form of an amendment that is allowed for a provisional application. It seldom happens that a provisional application will be amended. Although in some instances it may be necessary in order to have fair basis for your complete application from that provisional to first correct any obvious mistake that was in the provisional specification so that you have valid fair basis when you complete the application. Okay, then if we move on to amendments for pending patent applications in terms of section 51, subsection 6, it states that no amendment of a complete specification will be allowed if the amendment introduces new matter or matter not in substance disclosed. Or it also then goes further on to say that no amendment will be allowed if the specification as amended would include a claim which is not fairly based on subject matter disclosed in the specification before amendment. Okay, so two very important provisions to take note of here. You cannot amend a pending patent application if you wish to introduce new matter. So if we have a look at the bottle and cap example again, your patent specification only discloses this bottle in the specification, and you only claim the bottle in the specification. So you cannot amend the patent specification to add new matter, which is this cap, because I have not previously included this in the specification. So this cap would be considered new matter. So that's not permissible. You cannot claim something which you haven't applied for at the time of filing the application. Do you all follow on that provision, what we mean by no new matter? Okay, then if we look at the second provision of section 51.6, it says that you cannot amend the specification to include a claim which is not fairly based on subject matter disclosed in the specification. So we did discuss this briefly yesterday. So whatever is in your claims has to be found within the patent specification itself. So if, for instance, you include a range, say a range of 0.5 to 1 milliliters of water in the patent specification, you can't, in your claims, then claim something that falls outside of that range because there's no fair basis for that in the description of your specification. So whatever is claimed must be disclosed in the specification itself. Then if we have a look at the amendment in terms of a granted patent. So a patent can be granted at any time. However, it is a bit more onerous to amend a patent specification once it has already proceeded to grant. Again, the same two requirements apply as does for patent applications. Nicole, you have a question?
Hi, good morning.
Hi, morning.
In that case, what would you then suggest be the best course of action to take in such an instance as the example that you just provided?
So where there's no fair basis. Well, in that case, you could most likely depend on a patent of addition, where there's matter that is fairly associated it could be a modification to that invention. So I would suggest either filing a patent of addition. There's also provision for supplementary disclosure where you can add new matter, and that is something that we'll have a look on a little bit later on during the course of today. But a patent of addition in that instance would probably be the most viable option or route to follow in that case.
Okay, perfect.
Fantastic.
That's what I also thought. Thank you so much.
Okay, pleasure. Okay, so if we go back then to a granted patent, as I said, the same provisions apply as for pending application where you cannot add new matter, and there also has to be fair basis for the claims in this specification. But then there's a third provision that says that the amended claims must fall wholly within the scope of the claim included in the specification before amendment. And what that basically means is that you can't broaden the scope of the claims. So you can introduce a narrow amendment by deleting an integer, for instance, but you can't add integers to something that may have been disclosed in the specification but wasn't previously claimed. So you're not able to broaden the amendment or the claims rather. Also, when it comes to an amendment that is made after an application has proceeded to grant, so where the patent certificate has issued, that amendment needs to be advertised. So the Patent Office will publish a notification in the Patent Journal that states that the patent is being amended, and then any person can oppose that amendment within a 2-month period. So for any other amendment made to a pending application, there's no opposition to that amendment. However, once it goes to grant, there can be opposition to that amendment made to the patent. And that's provided for in section 51.2 and section 51.3. So if we just read through those briefly, it says an amendment of a patent after grant must be advertised in the Patent Journal. Any person may oppose such an application for amendment within the prescribed time, and that time, as I said, is 2 months in terms of Regulation 53 and in the prescribed manner. So the prescribed manner, there's a specific form in the patent regulations, I believe it's Form P19, on which you would make your application to oppose that amendment. And then any opposition that is lodged in respect of that amendment will be dealt with by the Commissioner. So just something to bear in mind that there are 2 parties at play and often referred to in the Act. There's the Registrar of Patents and then also the Commissioner of Patents. I don't want you to confuse these 2 bodies. So the Registrar of Patents sits at the Patent Office and oversees the formal aspects of the application, as well as the restoration. But a lot of the times the powers are then shifted to the Commissioner of Patents. Now, the Commissioner of Patents is an appointed High Court judge that sits in Pretoria High Court. Okay, so that's the only court that can hear matters relating to patents. That's the High Court in Pretoria, or the Court of the Commissioner of Patents, as is the correct reference. Then, as I said, there's also provision for any amendment made during the course of legal proceedings in terms of section 51.9. So where in legal proceedings involving a patent or a patent application, any application for the amendment must be made to that court and not to the registrar. So again, the Commissioner will then decide on that amendment and not the Registrar of Patents. And then if we have a look at section 51.10, the Commissioner of Patents is also given the authority to set aside any application or any amendment where application is made to him. Okay, so now turning to a supplementary disclosure, and this is what I raised with Nicole in her question. The Act makes provision for supplementary disclosure in terms of Section 51(8) and Regulation 52. Yeah, it says that where an amendment may not be allowed by reason of the prohibition imposed by subsection 6A, but it describes matter which may be fairly associated with the matter described in the specification as framed, and the acceptance of the specification concerned has not been published in terms of Section 42. The new matter may be introduced by way of a supplementary disclosure attached to the specification and dated with the date on which the application for amendment is made, provided that in determining the validity of the patent under this Act, regard shall be had to the priority date of the new matter introduced by way of the supplementary disclosure. So again, if we have a look at that example of the ranges, it is possible to introduce that range that falls outside the range that was disclosed, provided that it can be proven that it is fairly associated. So again, don't be confused between fairly based and fairly associated. They're two separate concepts. However, with the supplementary disclosure, you have to file your supplementary disclosure before the acceptance of the application. Sorry, before it's actually proceeded to grant. So you can only add a supplementary disclosure during the pendency of an application and not after. Remember, with the patent of addition, you can apply for a patent of addition after grant as well. So at any time. And those are two of the distinctions between a patent of addition and a supplementary disclosure. So as I've shown you, as with a patent of addition, it's a mechanism where you can add new matter, but it must be fairly associated with the matter that is described in the specification. Again, it has to be filed before grant. And then the priority date of the new matter, so the date where the court will consider the novelty of that new matter that is added, will be the date of filing of that supplementary disclosure. And then, as you can see there, I've also highlighted that another way of protecting new matter is by filing a patent of addition. Okay, so there are two various mechanisms that can be used. Just so that you also recall the distinction between the patent of addition and supplementary disclosure. A patent of addition is provided with a new application number. It also is accepted. It also goes through grant, where a supplementary disclosure is basically an annexure to the already existing application. Okay, so for the patent of addition, you'll end up with two separate patent or letters patent documents. Oh, sorry, just if you... I'm just being interrupted briefly, sorry all. Sorry about that, everyone. So just bear that distinction in mind then as well. Any questions that you have on this point? No. Okay, something to consider as well if we have a turn back to the PCT. You may recall that I mentioned the Article 19 and Article 34 amendments yesterday, where during the international phase, you can amend the application, and that is either by way of Article 19, that's prior to your request for a demand. So where you have made amendments to the international application, those will be done in terms of Article 19 of the PCT. Or if you file a demand and lodge a set of claims or any amendment with that request for demand, that is done in terms of Article 34 of the PCT. And if that amendment is made during the international phase, that amendment is carried across through to the South African application. So once that amendment is lodged during the international phase and it is attached to the IPRP. It has to be attached to the IPRP. In that case, it will then be considered an amendment allowed in South Africa. And that will then form part of the patent specification in South Africa. So just bear that in mind as well if ever you in practice will come across one of these amendments. Then section 52, this provision allows for the registrar to make any rectification, correction, or amendment that he feels is necessary. And he can do this out of his own volition and without request from the patentee or the applicant. But it may also be done on request to him in terms of this provision. And that brings us to the end of corrections and amendments. Very important provisions, these. It's something that is dealt with in practice on a daily basis, more often than you can imagine. Most applications that enter the national phase into South Africa are amended to bring them into line with the requirements of South African law. Not just in terms of what the Act holds, but also in terms of precedents that have been set by the courts and what is permissible in South Africa and what is not. I think if it's okay with you, do you mind if we break until 10 o'clock? So we'll have a quick 9-minute break just to grab some water or coffee, and then I'll see you all back at 10 o'clock. Thanks, everyone. Okay, welcome back, everybody. I think we can get cracking with a new chapter. We'll be dealing with the rights in and to the inventions and patents. So who is actually entitled to apply for the application, and how is there proof provided to the registrar? Can these rights be assigned or not, and so forth? Just some of the topics that we'll have a look at. And maybe something that we should have begun with is section 27.1, that deals with who may actually apply for a patent application in respect of an invention. Now, obviously, it would be the inventor. If in the case where the inventor hasn't assigned his rights to anybody, then the application will be made in the name of the inventor. Or in the instance where the inventor has assigned the rights to the invention to a third party, then that person would be entitled to make the application. So as you can see from section 27.1, it's either the inventor or any other person acquiring from the inventor the right to apply. And as you may recall, this assignment from the inventor for the invention to a third party can be done in several ways. Some of the examples are just listed in the front of you. That's either by way of a deed of assignment, which is just a contract setting out that the inventor assigns his rights to the third party. It could be by a way of contract of employment, where the employment contract itself makes provision for the assignment of IP rights during the course and scope of employment. And these are often also included in the contracts when you file an application as a student to a university. You'll see that in that contract for most universities, there is a provision that any research conducted at the university, any intellectual property that might arise during the course of your studies, will automatically be assigned to the university. So just something to be mindful of as well for anybody that is in tech transfer offices. Then it could also be by operation of law, where there's a statutory provision. And if I recall correctly, the CSIR Act makes provision for the assignment of inventions for employees at the CSIR for those rights to the inventions to automatically assign to the CSIR. So just something to bear in mind. Then also, if an inventor has passed on, those rights will then be assigned to that estate or to the rightful heir in that case. So even by way of succession, those rights can then be transferred to a third party. But remember, an application doesn't necessarily need to be made by one person only. There can be a joint ownership of the rights to the invention and then into the application. And this is dealt with in terms of section 29, where it says that if there is no agreement to the contrary, joint owners have equal and undivided shares in the application, meaning that the rights to the invention are split 50-50 and in the application split 50-50, but in an undivided share, meaning that they have ownership as a whole over the invention. Not only inventor A has ownership of the integers A, B, and C in the claim, and inventor 2 the rights to the integers D, E, and F in the claim. They have an undivided share in the rights to the application and invention. Then it goes on to say that none of them may deal in any way with the application except to save the application from becoming abandoned without the consent of the other joint applicant or applicants. So it's not possible for one party to assign their rights in the application to a third party, for instance, without the other applicant giving their consent to do so. So there has to be a mutual consent between the parties before one party can take action on that application. And that will also be applicable to licensing, for instance. The only provision or exclusion is that one applicant may proceed with the renewal of the application without the consent of the other party. and that is then obviously to preserve the rights that may arise once the application proceeds to grant. If there is a dispute that arises between the applicants, this will then be dealt with before the Commissioner of Patents. So this is a matter that will be decided on by the Commissioner of Patents. The party that brings that application is liable for the costs and expenses. If there's a dispute of those rights and the Commissioner finds that there's a dispute as to the ownership and one party is entitled solely to that application, then the Commissioner may order that the other party assign their rights to the applicant. But he must then consider that compensation be awarded to the other party that is now assigning their rights. So the assignor should be given just and equitable compensation for their share in the invention. In all these instances, the court will always favor the preservation of the patent application. So the court will ensure that the rights to the invention aren't lost, that the patent rights aren't lost, and unless good reasons are shown to the contrary, the Commissioner is required to resolve the dispute in a manner which will lead to the preservation of the application and to see the application through to grant. Okay, so this provision relates specifically to the joint ownership of patent applications and how any disputes between the applicants themselves are then addressed. We then have a look at Section 28. This relates to disputes over the ownership of the invention, so not necessarily to the application or the patent, but where disputes arise between parties and their rights in and to the application and the rights to the invention. Again, such a dispute must be made to the Commissioner, very similar to the previous provisions, where the Commissioner then can oblige one party to assign any rights over to the third party or the applicant, and also again to award just and equitable compensation. It also then goes further on to say that those rights to the invention may be assigned with the inclusion that it provides for foreign rights, for worldwide rights. So if an application is being made abroad, that those rights to those inventions or that application in abroad would then also be assigned to the applicant bringing the application for this dispute. Then Section 49, very similar to the previous provisions of Section 29, but whereas Section 29 dealt with applicants, Section 49 deals with the ownership into the patent itself. So once the application's proceeded to grant, Section 49 deals with the disputes between co-patentees and also how their rights are limited as co-patentees and what they are entitled to. So again, similar to Section 29, if there's no agreement to the contrary, the patentees are entitled to an equal and undivided share in the patent. Again, any proceeding may be brought before the Commissioner of Patents to adjudicate on any ownership issues. However, what is allowed when it comes to the joint ownership of patents is that one patentee may institute proceedings for infringement for patent. However, they have to give notice to the co-patentee that they seek to pursue infringement proceedings. In that case, the co-patentee can join the proceedings, but if they choose not to, they are not entitled to any reward that is granted by the Commissioner of Patents. So if there are joint patentees, one patentee can proceed with infringement without the other, provided that notice is given to that party. They then can decide to join the proceedings for infringement or not. But if they choose not to, then, as I said, they are not entitled to any compensation that is awarded by the Court of the Commissioner of Patents. Again, similar with patent applications, any patentee can then attend to the payment of renewal fees to ensure that the patent is maintained and kept in a valid or enforceable form. If we continue with section 49, a lot of what I have reiterated already regarding the damages to the plaintiff, and then the disputes that would be heard before the Commission of Patents, should they arise between the parties who are owners of the patent. And again, you can see the same provision in the last bullet that is found in section 29, where the court has to consider the matter in a manner which favors the preservation of the patent. Okay, if we then have a look at section 59, which deals with the assignment of the rights, section 59 provides that the rights vested in to a patentee or an applicant shall be capable of assignment. It's quite a arbitrary provision. I mean, it is an asset that you can, so I don't know why specific provision was made for this, but it just basically says that the rights to the application or patent can be assigned. One thing to take note of is that there are provisions in terms of contracts of employment which are not allowable in terms of the Patents Act. So the first is in terms of section 59(2)(a), it says any condition in a contract of employment which requires an employee to assign to his employer an invention made by him otherwise than within the course and scope of his employment shall be null and void. So if I, as an employee of Spur & Fisher, devise an invention that relates to my work, that can be assignable to my employee. But if I go home and create an invention relating to woodwork, I cannot be obliged by way of an employment contract to assign those rights to my employer. So only rights within the course and scope of employment can be assigned in terms of the contract of employment. Any invention that's devised outside of my course and scope of employment cannot be transferred to my owner by way of contract. Then it also provides for a restraint of trade. Hi, Jacques.
Sorry, Margaret, just a quick one. With regard to any work created in the course and scope of your employment, if you were to go home after hours and you created something which it could be said to be roughly in the course and scope of your work, but it was done after hours on your own equipment, using your own time, would that still fall under this provision?
I don't think so. And I mean, if I recall correctly, it's the South Africa Weather Services case. Tato, you might know that one, correct? Even if it is done outside of working hours, the court might consider that you garnered those skills due to your employment, and that should then be the employee's rights or then vested to them. Yeah. Jabulani, you have a question?
Yes. Is this also the same case with this guy who divided the please call me? Because from what I heard, the little that I heard was he was actually employed as a security guard at the company. Then I don't know, is this something to do similar like that?
Look, I'm sure a provision like this would apply. To be honest with you, I haven't followed that case as well as I should have, so I'm not too familiar what his previous employment was, and whether he was employed as a security guard. I don't know if that is true or correct. I don't think that is the case. But if he did devise it during the course of his employment, say he was as a technician or something along those sorts, then those rights would probably vest in Vodacom. But if it was outside the course of his employment, then this provision would kick into play, where those rights cannot be transferred to Vodacom.
Thank you.
Look, I think with that Vodacom case, there's also a lot of public outcry, which could also persuade, the outcome of that matter and whether it's just and equitable. So a lot of public policy at work there. Yeah. So then if we have a look at the second provision, which is deemed null and void, that's basically a restraint of trade. So if you left the employment of your employer and you have been away for more than a year and you devise an invention that even relates to the work that you were busy with, that employer can't now claim that invention. So if you want to be sneaky, you can wait a year and then go ahead with your development. But as you can see, it says any condition or contract of employment which restricts the right of an employee in an invention made by him more than 1 year after the termination of the contract of employment shall be null and void. Okay. If we move on to section 61, the applicant or patentee may in writing assign his rights. This is something to be aware of. The rights to an application or a patent have to be done in writing. It cannot be concluded verbally, specifically because of this provision where the Act provides for that the assignment should be in writing in respect of an application or a patent. It is important to note that this should be recorded in the patent register. So if an application was filed in my name and I assign my rights to title, then that should be recorded in the patent register to reflect that the rights to that application were assigned from me to title, and that title is then recorded as the assignee on that application. If that is not done, then that assignment has no effect against third parties. So as you can see from the third bullet there, unless it's so recorded, the assignment is not valid except between title and I. So it has no effects against third parties. Also, if you don't record that assignment timeously, and by timeously I mean within 6 months of the effective date, so from the date that title and I assign or agree to the assignment, within 6 months from that effective date, you should record the assignment at the South African Patent Office in the patent register. If you don't do that, then you have to request condonation from the Registrar of Patents to excuse the late recording of that assignment, which then incurs additional costs. So just something to be aware of. Again, if we then go on to section 62 to 66, not something I'm going to deal with in much detail, but just to be aware of it, as with any asset, it can be attached, you can hypothecate it, so just be aware of those provisions. If there is a hypothecation on the patent, then you are not allowed to alienate or encumber or conclude any licenses over that patent. So you have to keep it in force and in its present form. Okay, if we then move on to the next chapter, which is licenses, where we're going to specifically look at the provisions in terms of compulsory licenses. Now, two provisions are made where the Commission of Patents, excluding provisions relating to government acquisition or expropriation, but where you can apply for compulsory license. Now, there are two instances where this may arise. It's where there's an abuse of rights by the patentee or where there is a dependent patent. But we'll deal with that in a little bit more detail after this section. So if we look at section 56, it says any interested person who can show that the rights in the patent are being abused may apply to the commissioner. So again, this is before the High Court in the prescribed manner for compulsory license under the patent. So any party that has a vested interest can apply for a compulsory license, provided that they can prove that the rights in the patent are being abused. But when is a patent being abused? And this is provided for in section 56, subsection 2, which says the rights in a patent shall be deemed to be abused if the patented invention is not being worked in the Republic on a commercial scale or to an adequate extent after the expiry of a period of 4 years subsequent to the date of application, or 3 years subsequent to the date on which the patent was sealed, whichever period last expires. And there is, in the opinion of the Commissioner, no satisfactory reason for such non-working. So this will happen where, in the case you're granted a patent, but you're not actually commercializing that patent. That may be then considered an abuse of rights. So unlike with trademarks, there's not necessarily a requirement where you have to work a patent, but if you do not work a patent, you run the risk of being forced to then license your patent to a third party should you not be working it, and that there's no valid reason for that. Then the next provision is the demand for the patented article in the Republic is not being met to an adequate extent and on reasonable terms. So you can't supply the demand that is necessitated in the country. I mean, quite straightforward provisions, but very difficult to prove in practice. Then there's also considered to be an abuse of right. Lambert, do you have a question?
Yes, thanks. I hope it fits in the context of our discussion. I once read a couple of years back in the Scientific American about patent walling. Could you explain that concept? And the argument was that America is stifling innovation through patent walling compared to the practice followed by the UK. So maybe if you could, I hope it fits in with our discussion. Would that be an abuse, for example, if you do patent walling, not really having the intention to use those patents? Or yeah, I would appreciate that. Thanks.
Look, it would only depend if those rights have been extended into South Africa, where you can then actually rely on this provision. So if there is that application or patent in South Africa, because remember it's territorial. So if America doesn't have those rights in South Africa, then any party is allowed to exercise that invention without any infringement. So only in the instance where they're not working that patent in South Africa, I don't know for what reason they would do that, but in that case, you would be able to rely on this provision where they're not actually working the patent itself, where there's no commercialization of the invention which is subject to that patent. Does that answer your question?
Yeah, I think it does. I was thinking whether those are additional applications that you file around your main application. So maybe it fits more into a patent of addition than this within the context of compulsory licensing. But I was just wondering whether you've come across in practice whether a client would ask you, I want to protect this specific core patent of mine, which I intend to exploit and commercialize, but almost defensively, which is not my core business, I keep out other patents from being used by my competitors. Is that something that you've encountered?
It's not something that I've encountered, but that might fall more within the realm of a dependent patent, where you as a party aren't able to exercise your own invention without infringing on another party's invention. And in that case, you can then be ordered a compulsory license in terms of a dependent patent. So I think that would be more applicable to this scenario where you are able to exploit those rights of somebody else if they're not being fair in awarding you with the license in a commercial realm. Okay. I mean, one thing that, apart from patent walling, I mean, is the patent trolling that takes place in America as well, where they file patents for nearly everything willy-nilly. and people that will then just sit and buy these patents from an applicant or the patentee and not work them in America. And then as soon as somebody tries to infringe on those rights, they will then abuse the courts and go ahead with infringement litigation. So they actually buy these patents, sit with them, don't commercially exploit them, but as soon as somebody as close as infringes on those rights, they try to take them to court and gather compensation, which is quite a problem in America. That's one thing that does take place there, which I think is quite an abuse of the system, but very smart actually. But anyways, okay, if we then move on to the next provision, it says by reason of the refusal of the patentee to grant a license or licenses under reasonable terms. So in this case, where you would have requested a license, but the patentee refuses it and is being unreasonable in doing so, and the trade or industry or agriculture of the Republic, or the trade of any person or class of person in the Republic, or the establishment of any new trade or industry in the Republic is being prejudiced, and it is in the public interest that a license or licensee or licenses should be granted. So again, I think this is where public policy comes to play again. In terms of COVID, they could probably rely on the grant of a compulsory license, to possibly manufacture a vaccine if the public interest or the public is being prejudiced. Then if we have a look at the next provision, it says the demand in the Republic for the patented article is being met by importation, and the price charged by the patentee, his licensee or agent for the patented article is excessive in relation to the price charged, therefore, in countries where the patented article is manufactured by or under license from the patentee or his predecessor or successor in title. So quite a lot contained within the provision. So this is where the demand within the country is being met by importing the product from overseas, but then that the price that is being charged also has to be successive. So it's not an or provision, it's an and provision. So all those requirements have to be met in order for a compulsory license to be granted in this instance, where the demand is being met by importation, and the price is being charged is excessive. Just one thing to note when you are answering the examination questions, to be mindful of a situation like this where you're perhaps asked to provide what would be considered an abuse of patent rights. You can't just say in this instance that the demand is being met by importation. Okay, it's a twofold answer here. It has to be met by importation and the price must be excessive. Okay, so just keep that in mind to ensure that you cover all the bases within the provisions of the Act. Okay, so those are the instances where there would be an abuse of rights. But as I said earlier, no compulsory license has ever been granted in South Africa. I mean, you can imagine that it's quite difficult for a party to prove an abuse of rights. Okay, this just then goes into the provisions relating how you would go about being granted the compulsory license. So it says any party appearing to the register to be interested in the patent may prescribe the application for the grant of a compulsory license. It says that the commissioner shall consider it, and so on and so forth. This is something that you can, again, work through in your own time. I mean, it is quite self-explanatory, and I'm not going to reiterate all of this. You can work through this as self-study then. As you can see, it's quite a lot for me just to sit and read out. There's not much explanation required from my part here. But then if we look at the second provision, where a compulsory license can be granted or second instance. That is for a dependent patent. So this is where the working of the patent without infringement of a prior patent is dependent upon the obtaining of a license under that prior patent. The proprietor of the dependent patent may, if agreement cannot be reached as to such license with the proprietor of the prior patent, apply to the commissioner for a license under the prior patent, and the commissioner may grant such a license on such conditions as he may impose, but including a condition that such license shall be used only for the purposes of permitting the dependent patent to be worked and for no other purpose, provided that the commissioner shall not grant such a license unless the invention claimed in the dependent patent involves an important technical advance of considerable economic significance in relation to the invention claimed in the prior patent. The proprietor of the dependent patent granted the proprietor of the prior patent on reasonable terms a cross license to use the invention claimed in the dependent patent. The use authorized in respect of the prior patent is not assignable except without assignment of the dependent patent. Okay, so quite a lot going on in this provision in section 55. But as I explained earlier to Lambert's question, is that if you are the proprietor of a patent and there is an existing prior patent, but if you are to work your patent in South Africa, it would infringe on another party's patent. The court can consider that you be granted the rights to a license to exploit the prior patent's rights to that invention in order to enable you to work your patent. I guess this is to think of a practical scenario, perhaps would be cellular technology, for instance, where you have the patent to your cell phone. Okay, so there's a patent for the functionality of the phone, which is developed by Samsung in this instance. Then you have Intel that has created a chip for the processor of the phone. Okay, Samsung's isn't able to work their patent and use Intel's chip without their consent. So if Intel is being unreasonable in granting a license for Samsung to use the Intel processor, then they can apply for a dependent patent. But as you can see, there has to then be a cross license between the parties in terms of the granting of a dependent patent. Okay, I hope that's a good enough example that answers what this might relate to. Are you happy with that, Tato?
I have a question.
Yes.
The term, was it friend, fair, reasonable, and non-discriminatory in the other jurisdictions? Is it in relation to this, that sort of thing, dependent patents or so forth?
I'm not too certain. Sorry, I'm not following the question.
You know the acronym FRAND, F-R-A-N-D, fair, reasonable. Yes. Is it related in our jurisdiction, because we don't have a similar term?
No.
Is it related to dependent patent?
No, I don't believe so. No. Okay. Okay, but does everyone understand the concept of a dependent patent then? So you can't actually exercise your rights without infringing, or if you wouldn't have a license where you would infringe another patent. So in that case, during the ordinary course of business, you would require a license from the other patentee to be able to exploit your invention. And that's what this then relates to, is in that scenario where the prior patentee is being unjust and unreasonable in awarding you with a license. You can then turn to the Commission of Patents to request grant of a dependent patent. But just take note of the three additional provisions here, that there has to be a cross license awarded to that party, and also that you can't assign the rights then without assigning both applications or both patents. Jacques, you have a question?
Sorry, it might be a bit of a silly one, but obviously the prior patent isn't claimed in the specifications. There's no claim for that prior patent, but it is included in the working of it. So obviously your claims would pass grant. It would be seen as not infringing on this prior patent. However, the working of it requires that on a commercial basis.
Yeah. So, I mean, if say the patent relates to the whole phone, or, you know, the operation of the phone, you know, the claim would relate to the programming, you know, a processor, you know, and that would be the Intel chip in that instance. So it doesn't necessarily say that they manufacture the processor. It's just that it has a processor.
Yeah.
Okay. So, yeah.
Okay.
Okay, and that then brings us to the end of compulsory licenses. Any other questions that anyone might have? Not comfortable with that. Again, we did discuss this earlier in our debate regarding the government's acquisition of the rights to a patent. Please do have a look at that article that I wrote specifically on those provisions. You'll see that I brought that up in the last 2 years past examination papers, mostly because it was a very hot topic at the time regarding COVID. Just some other provisions that you need to be aware of is section 53, which is a license of right. As you can see, I haven't reiterated the whole section here. What that deals with is that you as a patentee can basically mark the patent register to say that you are very happy and willing to offer this patent as a license to anyone. They can then make use of the patent and it will be endorsed that there is a free use to that patent. If you do that, the benefit to the patentee is that he only has to pay 50% of the renewal fees due on that patent. But again, that's probably only a saving of like 80 Rand at most. So not much of a benefit really to the patentee to endorse their patent as a license of right. Maybe with the amendments to the Act, they'll reconsider the official fees that are payable for renewals, hopefully. And then section 54 is just how to go about cancelling that endorsement on the patent as a license of right. Again, you can have a look through section 57 and 58, not something that I'm going to touch on at the moment. Then if we have a look at section 91, this is very applicable to any attorneys here that might draft commercial agreements, license agreements, to be familiar with these provisions, where these provisions are excluded or deemed to be null and void if they are included in a contract, and especially in licensing agreements. So it says that any condition in a contract relating to the sale of a patented article or to a license under a patent of which the effect will be to prohibit or restrict the purchaser or licensee from purchasing or using any article or class of articles, whether patented or not, supplied or owned by any person other than the seller or licensor or his nominee. So you can't prohibit the licensee from purchasing a product which is not sold by the licensor. Then if we have a look at the next provision, it says to prohibit or restrict the licensee from using any article or process not protected by the patent. So the licensee cannot prevent the licensor cannot prevent the licensee from using an article which is not subject of the patent. Mark, you have a question?
Yeah, sorry, just on that first one, how then does sole distributor agreements work? Because then, I mean, you're limiting the scope of the sale for that patented item to that supplier, I suppose, the original patent holder.
Yeah, so you can't limit it to a specific supplier unless it relates to the patented invention itself. So anything outside of the patent, you can't restrict the licensee then from not acquiring those products elsewhere.
So arguably, I could sell, I've got a license to sell aspirin.
Yeah.
But there can't be a restraint within that agreement, that licensing agreement, that prevents me from selling Disprin.
Well, yeah. Look, I mean, the composition's probably pretty much the same. So in that case, the patentee would be the same for both of those compounds. But say it was an unrelated product, then you can't restrict that person from the unrelated product that's not subject to the rights in the invention.
Okay, so the related products we probably can, but
Yeah,
unrelated not. So
yeah,
aspirin, and then I think yesterday's examples, Viagra, fine, off we go.
yeah.
Okay, thank you.
No problem. Then if we move on to C, to require the purchaser or licensee to acquire from the seller, licensor, or his nominee any article or class of articles not protected. So this is very much quite similar to the first provision that we went through in one above. I just need to clarify what the distinction is exactly there, but I'll turn back to that again. Then if we have a look at D, to require or induce the purchaser to observe a specified minimum resale price in respect of any article or class of articles protected by the patentee or by the patent. So you cannot set a minimum resale price on the product that is subject to the license agreement. Then you also cannot prohibit or restrict any of the rights granted in terms of the patent. So that's the making, using, exercising, or disposing of the invention in any country in which the invention is not patented. So if there is no patent for the invention in Botswana, for example, the license agreement can't restrict you from manufacturing in Botswana. I mean, the patent rights don't extend to that country. So it's only limited to the country where it exists. Something also just to bear in mind, if ever drafting license agreements, is that the license relating to the patent can only extend for the duration of the life of the patent. So only for 20 years that license agreement in respect of the patent will be valid. Okay, if we then look at section 92, it says nothing in this section shall affect any condition in a contract whereby a person is prohibited from selling any goods other than those of a particular person, or affect any condition in a contract for the lease of or a license to use the patented article whereby the lessor or licensor reserves to himself or his nominee the right to supply such new parts of the patented article other than the ordinary articles of commerce as may be required to put or keep it in repair. Okay, so something that you can just have a look over again, but please do draw specific attention to section 91 for the examination purposes. Let's have a look. How are we doing for time? Okay, I think we can then move on to the next chapter. Hi, Sibulele. Sorry, I missed your hand. I can't hear you. Sibulele, there's no audio coming from your side. Perhaps if you'd like to ask the question in the comments, I can answer it and we can return back to it because I'm not receiving your audio. Okay, I think let's move on then to the restoration section. So as you'll recall, I mentioned yesterday that if the renewal fees have not been paid in respect of the maintenance for the patent and to ensure that it is in force and the patent lapsed due to the non-payment of those renewal fees, provision is provided for the restoration of that lapsed patent, provided that the requirements in terms of Section 47 are met. So if we have a look then at Section 47, it says that where a patent has lapsed owing to the non-payment of any prescribed renewal fee within the prescribed period or the extended period referred to in Section 46(2). So you'll recall that that is the section that provides for an additional 6-month grace period within which to pay the renewal fees subject to late fines. Then the patentee may, in the prescribed manner and on payment of the prescribed fee, apply to the registrar for the restoration of the patent. So very important to note here that an application for the restoration of the patent is made to the registrar of patents. It's not to the Commissioner of Patents. So this function sits with the registrar of patents at the patent office and not within the court of the Commissioner of Patents. Okay, unless there is an opposition where it then shifts to the Commissioner. But it is the duty of the registrar to actually assess the application for the restoration of a lapsed patent. Then Section 47(2) provides us with the requirements that must be met in order for a patent to be restored. It says that if the registrar is satisfied that the omission was unintentional and that no undue delay has occurred in the making of the application, he shall advertise the application in the prescribed manner, and thereupon any person may within such period as may be prescribed give notice to the opposition of the restoration of the patent. So if we have a look there again, the two requirements that must be met in order for a patent to be restored in the event that it lapsed, that omission to pay the renewal fee must have been done unintentionally. And then secondly, when you find out that the patent has lapsed, you need to bring your application for restoration without any undue delay. So as soon as you find out that your patent has lapsed, you need to make application for the restoration of that patent. So if you receive an instruction as your client's patent attorney that they wish to allow the patent to lapse, you mustn't pay the renewal fees. They then can't later on wish to restore the patent because they won't meet the unintentional requirement. There must have been an unintentional failure to pay that renewal fee. And this does arise quite often, where a secretary hasn't possibly docketed the dates correctly and the payment of that renewal fee is then missed. That would be an unintentional omission to pay the renewal fee. All right. And then that no undue delay has occurred. So as I said, it's quite self-explanatory. As soon as you find out about the lapsing of the patent, you should make your application without any undue delay to the Registrar of Patents to restore the patent. Okay. If those requirements are met, then the application for restoration is published in the Patent Journal for an opposition period, and that opposition period is again for 2 months. So any member of the public may oppose the restoration of the patent. If there's no opposition after that 2-month period has expired from the date of publication in the Patent Journal, then the registrar will issue a certificate known as your registration order, restoring the rights to the patent. And upon that issuance of the registration or restoration order, or renewal fees that should have been paid must then be paid once that order is issued, as at the date of the issuance of that order. But in the instance where there is opposition to the restoration of the patent, then that matter shifts from the duties of the registrar to the Commissioner of Patents. So it will move to the High Court for the Commissioner of Patents to hear the objections. And the Commissioner of Patents will then decide on whether the patent should be restored or not. Any questions that you might have on this? Okay. So again, this is just a reiteration of what we've gone through. So you can only apply for restoration, obviously, after that 6-month grace period has passed, because that is when it will be lapsed. Prior to that, it's only provisionally lapsed. And you'll recall that it says that the application may be made to the registrar in the prescribed manner. In terms of regulations 49 to 51, it is prescribed that the application be made as an ex parte application to the registrar in a form as near as possible to a notice of motion that you would use for High Court proceedings. And then in that application, you will include one or more affidavits setting out the facts as to why the application or why the patent had lapsed. So in your affidavits, you would have to aver and provide the facts behind why the patent had lapsed, and also show that the application for the restoration is brought without any undue delay. So do make sure that if ever you are drafting a restoration application, that you specifically ensure that you comply with the requirements and set out the facts to address the requirements necessary for the restoration of the patent. Again, just a reiteration of what we have said already, and the specific sections that those relate to. So nothing that we'll delve into much more here. Okay, but once the patent is restored, so if it is decided by the registrar or the commissioner that the patent be restored, the rights of the patentee of that patent then become limited in terms of section 48. So if we have a look at section 48, it says a patentee or a patent restored in terms of section 47 shall not, by virtue of the provisions of this act, institute any proceedings against or recover damages. So you can't institute infringement proceedings or recover damages from any person who infringed the patent after the lapse of a period of 6 months from the date on which the renewal fee was due. So that is after the 6-month grace period. So if any third party then starts to use your invention, which has lapsed after that 6-month period, and before the dates on which the application for restoration was advertised. So remember, if the registrar is satisfied that those requirements are met, he'll advertise it in the patent journal. So between the lapsing of the patent and that advertisement date, if any party was to infringe the patent, had it been in force, the patentee cannot institute infringement proceedings against that party or recover any damages in that case. Okay, then it goes on further to say, if any person used, offered to disposed of any article made or imported in the period referred to in paragraph 8. So again, the same period that's applicable, where they committed any one of those acts of infringement, no action can be taken against that party. Then again, same period as set out above, commenced using or exercising the invention to which the patent relates, and who thereafter continues to use or exercise the invention, or uses or offers to dispose of or disposes of any articles or products produced by the continued use or exercise referred to in subparagraph 1. So you can end up in quite a sticky situation if you're a patentee and you've allowed your patent to lapse and a third party then commences using your invention, because as you can see from this section, they are duly allowed to continue using or exercising the rights over that invention without any recourse to the patentee. So very important to make sure that you don't allow the patent to lapse, so that you don't end up in a situation where you're sharing your monopoly with a third party, which you never intended on sharing it with. Okay. And then it goes on further in section 48 to say that where a patent has been restored under section 47, any person who during the period referred to in subsection 1A has expended any money, time, or labor with a view to making, using, exercising, offering to dispose of, disposing of, or importing of the invention may apply in the prescribed manner to the Commissioner of Patents for compensation in respect of money, time, and labor. So again, just to reiterate, you as the patentee don't want to allow your patent to lapse unintentionally, because again, you can end up in a situation where you're ordered by the commissioner to compensate somebody who has already expended money, time, or labor to exercise the patent which has lapsed. Then it just goes on further to say that the commissioner may, after hearing the parties concerned, assess the amount of such compensation, if in his opinion the application ought to be granted, and determine the time within which compensation shall be paid. Okay, so quite harsh limitations on the patentee in terms of section 48, if they allow the patent to lapse. One, the party can continue to exercise the rights over that patent in certain circumstances, and then also they can be awarded compensation by a court had they expended money or time or labor with a view of committing one of the acts of infringement that would otherwise infringe the patent. Good. Are there any questions on the restoration of lapsed patents? Okay, quite straightforward, but just do be aware of those limited rights of the patentee then as well, please. If we then move on to the revocation of the patent, this is where any third party at any time wishes to revoke the rights of a patentee of the patent and to revoke the patent. This is provided for in section 61(1). Very important provisions to know here. It says that any person may at any time apply for the revocation of a patent. Again, this application is made to the Commissioner of Patents, so this will be done in front of the Court of the Commissioner of Patents, who has jurisdiction to hear matters relating to the revocation of the patent. It's not dealt with by the registrar. This is the Commissioner of Patents that will hear a revocation application. So it says that any person may apply for revocation, so you don't need to show any particular interest in the patent. So any party can apply for the revocation of the patent. And again, it can be brought at any time from the date of grant up to the expiry, and even after expiry, provided that no provision. So really at any time after grant of the patent can be revoked. So the list that's provided for in section 61(1) is an exhaustive list. Those are the only grounds that you can rely on to revoke the patent. And this was then confirmed in the Busby case versus the Registrar of Patents, where it said that the absolute nature of the grounds of revocation was confirmed. So there can't be an introduction of other grounds of revocation. It is as it is in the Act. That is the gospel in this case. And also, as you may recall, yesterday I said in most revocation proceedings, the grounds that are relied on are often on more than one of the grounds. So just confirming that you can rely on more than one ground to revoke the patent. Also, if during infringement proceedings, if I as the patentee institute infringement proceedings against an alleged infringer, the alleged infringer can then counterclaim for the revocation of the patent as a grounds of defense during the course of those legal proceedings. So if we have a look more closely then at the grounds, so the first ground on which the patent can be revoked is that the patentee is not a person entitled under section 27(1) to apply for a patent. You'll recall we earlier discussed section 27(1) and who is entitled to apply for a patent. It is the inventor or any predecessor entitled. So if the inventor or the person that is cited as the patentee is not entitled in terms of that provision to actually have filed that application, then the application can be revoked. So it could also be an instance where the inventor is named is not the true inventor, or the inventor has been omitted, or the inventors are correctly named, but the applicant or patentee has not legally acquired the rights. So there hasn't actually been an assignment of rights from the inventors to who the patentee is. In that case, you could rely on this ground to revoke the patent. Then looking at the next ground is that the grant of the patent is in fraud of the rights of the applicant or any person under through whom he claims. So this is in instances where the conduct on the applicant's part is construed to be deliberately designed to deprive the objector, so the person that's bringing the application for revocation, either as the true inventor or as the assignee. So where a person was deliberately deprived of the rights in and to the invention, then you can rely on this basis. Then having a look at the subsection C, that the invention concerned is not patentable under section 25. So a very long list of provisions there that you can rely on, in which case the patent is not patentable. That could be because the invention itself is a discovery, it's a method of treatment, it's a computer program, any one of those, okay, are one of the grounds on which you can revoke the patent if it is not patentable in terms of section 25. Then if we look at subsection T, which is D, which is known as the inutility provision, this provision relates specifically to the description of the invention and not the invention as claimed. So the other courts would look at the description and not the claims in assessing whether the patent can be revoked on this provision. And this is where the patent cannot be performed or does not lead to the results or advantages as set out in the specification. So if we have a look at subsection D, it says that the invention as illustrated or exemplified in the complete specification concerned cannot be performed or does not lead to results and advantages as set out in the complete specification. So where the description itself does not clearly define how to perform the invention, or if the invention is performed, it does not lead to the results and advantages in the specification. And you'll often see when patent attorneys draft specifications, they'll steer clear often of including advantages of the invention, specifically for this provision. So, I mean, set out what it does. You don't necessarily have to provide what the advantage thereof is for this invention, because if it does not meet that advantage, then the patent can be revoked on the basis that that advantage is not met. Okay, if we then have a look at E, this is known as your insufficiency ground of revocation. So this is more based on a question of facts and whether a person skilled in the art can enable, what is contained in the specification provides proper instructions for enabling the invention to be put into use. So if we read it, it says that the complete specification concerned does not sufficiently describe, ascertain, and where necessary illustrate or exemplify the invention in a manner in which it is to be performed in order to enable the invention to be carried out by a person skilled in the art of such invention. So again, this is where there's matter that's lacking in the invention for a person that is skilled in that specific technology to enable them to actually perform the invention. Then moving on to F, it says that the claims of the complete specification concerned are not clear or fairly based on matter disclosed in the specification. So quite self-explanatory, and we did touch on this yesterday as well. Then having a look at subsection G, that the prescribed declaration lodged in respect of the application for the patent or the statement lodged in terms of section 33A contains a false statement or representation which is material and which the patentee knew or ought reasonably to have known to be false at the time when the statement or representation was made. So this again relates onto the declarations form P3 and P26. So the P3 is your declaration and power of attorney form, where a lot of averments are made in that declaration. And then the form P26 relating to the declaration regarding subject matter, which relates to indigenous or biological material, etc. So if any false declaration is made on those statements, which is material and which the patentee was aware of or ought reasonably have been aware of, can be revoked on that basis. So material misrepresentation is really any misrepresentation of fact, which if acted upon by the registrar would result in the applicant obtaining something to which they're not necessarily entitled to. And this case is a very important case in practice. It's the Benz Limited versus South African Leadworks Limited case. And this often arises in applications, especially that come from America, where they file an application that claims a certain priority. However, that priority is not necessarily the first application in respect of that invention. So they'll fail to admit that there was a previous application filed in respect of that invention. So say invention A was filed in the United States. In America, they will then file what is known as a continuation application or a continuation in part application, which is very analogous to a patent of addition where new subject matter is added or a divisional application. So when they then file the application in South Africa, they only claim priority from the second filed US application. And then this application, the first application, is completely out of the Paris Convention deadline. So out of the 12-month provision to file the application in South Africa. And this can cause quite a headache in practice, and is also one of the grounds on which the patent can then be revoked, because the patentee is declaring that the priority claimed in the form P3 is in respect of the first application for that invention, when in fact it's not entirely correct. And this arises quite often, as I said, you'll see from US applications that enter into South Africa. So if we do notice a situation like this from an American application, we'll often just write to the applicant, inform them of these provisions and ask whether there is any new subject matter added to their second application to ensure that they don't run into this priority issue. Okay, and this whole priority issue was what was raised in this case of Benz. And in industry, this has just become known as a Benz issue. So you may come across that term in future if you are ever in practice as a patent attorney. Okay, so basically where the priority claim is not in respect of the first application of that invention. Okay, so some of the elements that could lead to a misrepresentation from the Form P3 is obviously that the inventorship is incorrect, as we discussed earlier this morning, so that not all the inventors are named, or there are inventors that should be named on the application, that there's no proper assignment of the rights to the invention, because the P3 also avers that the applicant has obtained the right to the invention from the inventors. And if that's not the case, then there is a ground of revocation that exists based on this ground. Okay. So quite a lot rests on this declaration P3 and P26, which you can recall I emphasized quite a bit yesterday. And you know, it's become even more onerous with the amendment, because previously, prior to the amendment, the provision was only that the representation was material at the time, you know, when the declaration was signed, but it was amended to include ought reasonably to have known, which, you know, gives a court a discretion to decide, well, the patentee should have known about this at that time they signed the declaration. So it makes it more difficult. Then turning to the next provision, that the application for the patent should have been refused in terms of Section 36. We discussed 36 yesterday at quite length. So that is where it is frivolous on the ground that it claims an invention obviously contrary to well-established natural laws. So like your perpetual motion machines, or it encourages offensive or immoral behavior, or is contrary to law. Also possibly a nuclear energy related invention where you haven't complied with the provision in terms of the Nuclear Energy Act and sought the Minister of Mineral Resources and Energy's consent to proceed with the nuclear energy application in South Africa. So remember, as I said yesterday, if it is a nuclear related technology, you have to make the Minister of Energy aware that you have filed this application, and they then need to provide their consent to the applicant and to the Registrar of Patents that the prosecution of that application is allowed in South Africa. Then, if we have a look at the last provision, that the complete specification and claims, that the complete specification claims an invention of a microbiological process or product thereof, and the provisions of Section 32.6 have not been complied with. So this is a provision in terms of the Budapest Treaty, where if the invention relates to a microbiological process or product, you know, for example, your antibiotic, and you haven't made a deposit or provided that accession to the deposit of that microorganism, then in that case, the patent can also be revoked on that basis. Okay, everyone happy? These are the exhaustive grounds on which you can then revoke a patent. Please do familiarize yourself very well with this. This does pop up in every exam. So please, it's easy marks if you focus on this section. So make a NB, NB, NB in red all over your notes. Okay, then just moving on to the last few provisions that deal with revocation. It's Section 62. You'll recall yesterday when we were discussing divisional applications, and that often in foreign jurisdictions a unity of invention objection is raised, where the specification and claims claim more than one invention. But you'll see from Section 2, as you'll recall yesterday, I said that there's no recourse in that instance to any third party where an application or patent does claim more than one invention. And that's in Section 62, where it says a patent shall be granted for one invention only, but no person may in any proceedings object to a patent on the ground that it comprises more than one invention. Okay. Again, a subject of debates in practice, because some people may allege that, what is it that you're actually claiming? Are you claiming invention A, or are you claiming invention B? And, is there possibly a clarity issue in terms of the claims? Two different schools of thoughts that say that you can possibly rely on this provision, and others saying no, that it does not relate to that because of the specific exclusion in terms of section 62. Something, as I said, has never been brought for adjudication before the court. Then having a look at section 63, it says where a patent is revoked on the ground of fraud, or a patent fraudulently obtained has been surrendered and revoked, the commissioner may, on application of the inventor of the relevant invention or his assignee or legal representative, direct the grant to him of the patent of whole or any part of the invention bearing the same dates as the patent so revoked. So again, this is something that we touched on briefly yesterday, but if the patent is revoked on the second grant, where the grant of the patent is in fraud of rights. So if those rights were fraudulently obtained to the invention, then the court can grant these rights to the rightful proprietor, whether it's the inventor or an assignee. Okay, again, section 64, not something that we're going to discuss today, but this just deals with the voluntary surrender of a patent. Okay. Let's see, how much do you have left? Okay, we've actually made quite good progress. There's only about 20 slides or so left for the day. But if you don't mind, is it okay if we break now for a couple of minutes and then we return to finish off for the rest of the day? Sorry, my throat is getting a bit sore. Jabulani, you have a question?
I was just checking. Sibulele wrote something on the chat box. Maybe we could look at
Let me
that.
have a look. Sorry. Can you explain section 92 versus section 91? Okay, I'll do that once we get back then. Thank you. So it's now 20 past. I think let's break for half an hour. Have a good stretch of the legs. Maybe have a brunch or something. So let's return back at 10 to 12, if that's okay with everyone. So 10 to 12. So we'll take a quick half an hour break. So we should end off quite early today. That's not my fault. It's your fault for keeping so quiet. Nobody's asking me enough questions here. Okay, but I'm sure everyone would be quite relieved. It is quite a lot to take in. Okay, thank you, everyone. I'll see you then at 10 to 12. Enjoy the break. Hey, welcome back, everybody. I think we can continue with the final stretch of our session today. I'll just wait for my beautiful faces to turn their cameras on. There you go. Thank you all. Seeing as we are ahead of schedule for today, would you prefer that I work through the 2020 examination paper today, or should we leave that for the question and answer session? You maybe just indicate in the comments if you would prefer me to deal with one of the exam papers today and then leave another for the question and answer session. Alternatively, I'm happy to do them all during the Q&A session. Okay, nobody's providing. Okay, during the Q&A session, please. Okay, I think that is probably the better approach to afford everyone the opportunity to familiarize themselves a bit better with the work. Okay, fantastic. Thank you, everyone. We'll keep that then for the Q&A session. Just going back to Sibulelo's question where he asked if I can just go back to section 90, subsection 2, to have a quick look at that again. I can just find that. Okay. So this provision basically provides for a catch-all, well, not a catch-all, but it reiterates that those provisions of section 91. Oh, hello, Kitty. Welcome. I hope it doesn't come and take over my job. Thanks, Nicole. But basically provides that section 91 won't be applicable in the circumstances or situations provided for in section 90 subsection 2. So it says that nothing in this section shall affect any condition in a contract whereby a person is prohibited from selling any goods other than those of a particular person. So it is acceptable for a condition in a contract. I'll attend to your question now, Jeremy. So where there's a condition in a contract that prohibits anyone from selling goods from a particular person, those do not fall within the ambit of section 69(1), and that is permissible. Because remember, if you have a look at section 69(1), it relates more to the acquisition or use of articles. So you can have a look at subsection A. It's where you purchase or acquire or use an article of the patentee, or use the article of the patentee in subsection B, whereas this relates more to the selling of a product. Okay, and then if we look at subsection B, affecting any condition in a contract for the lease of or a license to use a patented article, whereby the lessor or licensor reserves to himself or his nominee the right to supply such new parts of the patented article other than the ordinary articles of commerce as may be required to put or keep it in repair. So this relates to spare parts. So if there is a condition in the contract or license agreement between the licensee and licensor, if there is a provision that requires the licensor to source the spare parts from the licensee, that is also permissible. So those provisions of subsection 91 won't prevent the licensor from including this restriction in the contract or license agreement, whereby the licensee is required to obtain spare parts that relate to that patented invention from being sourced from the licensor. Does that clear it up, Sibulelo? Oh, sorry, I mispronounced the name, Sibulele. Okay, I hope so. Hi, Tato.
Hi, Marco. It's just a practical question based on these contract conditions, based on a recent case. About 2 months ago, we're enforcing, I think it was copyright against a third party, and they brought the matter to the Competition Commission because our client is a dominant player in the market. And so we're sending out letters of demand for anti-counterfeiting to third parties as well. And one of the things they said is we're foreclosing them from the market, and secondly, it's anti-competitive. So based on the provisions you just explained, wouldn't that in competition terms be considered what, bundling? You bundle your goods and the others. And then I think the Competition Act, I think it's section 10, 10.2 of the Competition Act prohibits certain acts like that and says you can apply to the Competition Commission for an exemption if your acts with respect to intellectual property are anti-competitive. Would that be one of the things that you would apply for, or does it not apply under the circumstances?
Look, I can see how that's applicable in an instance where that product is not subject to a patent, because I remember the patented article is a monopoly right, you know. So it is anti-competitive in its very nature. So I don't know if that provision will extend to this, and ultimately it will be for the Competition Commission to adjudicate on that. So I can't give you a clear-cut answer as to whether it is applicable or not. But I don't see that it would be, because you are the proprietor of that article itself, and in respect of that invention, you know, so those rights extend to that proprietor, and he can do with it as he pleases.
That's the exact argument that the other side was disputing, is that competition law does not allow him to do whatever he pleases, including sending letters of demand or enforcing or vindicating their rights to infringement. So I was just wondering, what is the purpose of that provision? Because it's a monopoly right.
Yeah.
And that provision says if your actions in terms of intellectual property, and it covered all three, or the three main ones, amounts to anti-competitive, has an anti-competitive effect.
Yes.
Under the circumstances. So in principle, that would have an anti-competitive effect. So I think, like the last question then, what is the bearing on jurisdiction under these circumstances, since the High Court, the Court of the Commissioner of Patents has exclusive jurisdiction with respect to how you vindicate your rights in terms of patents.
Yes.
So exactly how far can the Competition Commission go in?
Yeah, in respect of, I guess, look, if it's unlawful competition, to be honest with you, I'm not entirely sure. You've actually stumped me on this one. It's another one that I'm going to have to ponder on, if that's okay, Tato. But to be honest with you, in respect of the patents, as you said, the Court of the Commissioner has jurisdiction. But I'm sure if you bring an action for unlawful competition, then it could possibly end up, although, you know, it might be a patent that is the subject, or even a part of that patent that is the subject of that unlawful competition. But my understanding is that all actions relating to the patent rest solely with the Commission of Patents. So I don't think that they would have jurisdiction to hear a matter like that. To backtrack on what I said earlier, yeah.
Okay, as a matter of interest, they assumed jurisdiction and they granted the order.
Sure. But that was in terms of copyright, though.
Yeah, in terms of copyright, okay. But the argument of the other part was very broadly couched in intellectual property and the rights of the Competition Commission. But yeah, okay, thank you.
No problem. Are there any further questions before we move on? Okay. Okay, so we've dealt with revocation. Infringement is next on the agenda. Again, we'll move through this relatively quickly. It's quite straightforward. If I can just quickly find my page. So in terms of section 45 of the Act, you'll remember that the grant to the right of a patent is a negative right that excludes others from committing certain acts. So if any of those acts are committed without the consent or i.e. a license to a licensee, then that would be an act of infringement. So if we look specifically at section 45, section 45 tells us what the effect of the grant of the patent is. So if we read through that, it says the effect of the patent shall be to grant to the patentee in the Republic, so our territorial rights for the patent in South Africa, subject to the provisions of this Act for the duration of the patent, the right to exclude other persons from making, using, exercising, disposing, or offering to dispose of or importing the invention, so that he or she shall enjoy and have the whole profit and advantage accruing by reason of the invention. Jeremy, I see your hands up. Can I answer your question?
Sorry, Marco, not a question. I just wanted to give you a heads up that you aren't sharing your slides at the moment. It's just everyone's faces on the screen.
I appreciate that. Thank you. Here we go. Sorry, I normally would have left it on, but I had an urgent matter to deal with during our break. Thanks for that, Jeremy. Okay, there we go. Hopefully you can all see that now. So section 45 tells us what the rights are that are granted to the patentee. It's that negative right to exclude others from making, using, exercising, disposing, or offering to dispose of or importing the invention. So these are very broadly worded terms, and those are the acts that an infringer would commit to infringe on the patent. So if anybody manufactures or imports that product, for example, that would be considered one of the acts of infringement. These words, obviously, in terms of statutory interpretation, would then be afforded their ordinary dictionary meanings. So if you want to have a look more at the ambit and the scope of what these acts entail, you can have a look at the dictionary. But there is a slide later on in the presentation that also does provide for a clearer definition of these acts of infringements. Okay, so please, section 45(1) is a very important section to remember, because these provide for the acts of infringement. It provides for the rights that are granted to the patentee. So please do take note of the effect of the grant of the patent on the patentee. Then having a look at section 45(2), it says that the disposal of a patented article by or on behalf of a patentee or his licensee shall, subject to the patent rights, give the purchaser the right to use, offer to dispose, and dispose of that article. And this provision is basically the provision that allows for the exhaustion of rights. As soon as the patentee has disposed of the patented invention, so if they've manufactured a patented article and they sell that to a third party, their rights in and to that article no longer exists with the patentee, and the third party can do with it as they please. Okay, so this is your exhaustion of rights provision, section 45, subsection 2. Okay, so who can bring an infringement application before the Court of the Commission of Patents? It's obviously the patentee. A licensee doesn't have any rights or any independent rights to bring an application. So if the patent has been licensed to a licensee, which is often the case, they themselves cannot bring an application for infringement proceedings. But the patentee is required, if they do wish to pursue infringement proceedings to notify any licensee that is recorded in the registrar, who can then intervene as a co-plaintiff in the infringement proceedings. So a licensee themselves cannot bring an infringement action. Only the patentee can, but they have to give notice to any recorded licensee. So again, this goes back to the recordal of the assignments that we spoke about earlier, is that it's only effective between the parties to that agreement. And the same provision applies for a license. So it's very important to ensure that any license that is granted is recorded in the patent register. And again, the same with an assignment that should be done within 6 months of the entitling of the grant of that license. Okay. Okay, so how do the courts go about determining infringement? You may recall the Ensign Bickford case, which was the case that provided the 4-step test when determining inventiveness that we discussed yesterday. In the same case, they set out the test in order to determine whether there is an infringement. So the first step that would need to be considered by the Court of the Commission of Patents is to decide whether the act that the alleged infringer is performing is indeed an act of infringement. So does it fall within the acts listed in section 45(1)? So is the act that this party is committing either making, using, disposing of, offering to dispose of, importing, or exercising the invention? Are they committing any of those acts? Then where the real inquiry takes place is that the claims have to be construed again of the patent itself, and then the alleged infringing article would also have to be construed. And again, a comparison to see whether all those integers are present within the alleged infringing article. So if we have a look at the wording from the case, it says that the court has to construe the claims to determine whether the alleged infringement falls within the scope of any of the claims. Sorry, this doesn't read correctly. Construe the claim. Yeah, so whether the alleged infringement article would be clearer, does fall within the scope of the claims. So again, a comparison of what is claimed within the claims. You'll recall that the claims define the scope of the monopoly. So those integers are then compared with the alleged infringing article. And if they do meet with each other, then there would be an infringement of the patented article. Then the court would also have to consider whether there is a valid defense. So again, basically, it's a comparison of the claims with the alleged infringing article in order to assess whether there is an infringement of the patent rights. Okay, so again, quite a straightforward inquiry, but the words that are used in the claims are often scrutinized and become the subject of hot debate during infringement proceedings. And again, if there is an infringement action, you may recall that as a defense, the alleged infringer can rely or can counterclaim for the revocation of the patent. So they can say, well, I'm not infringing because this patent is invalid and I wish to revoke it on the ground that it's either not novel or inventive, or any one of those grounds of revocation. Tato?
Marco, is it the exact same comparative exercise, different same thresholds? Because I'm imagining in a novelty and inventiveness comparison, novelty comparison, you're comparing documents under the circumstances. So if something is imported and there's no document to compare, how do you construe the claims of a three-dimensional manifestation of whatever?
Yeah, look, so it's not necessary. Well, I mean, there might not even be claims relating to that infringing article, but it's whether the integers that are defined in the claims can be said to be present in that alleged infringing article.
Okay.
Okay. So again, this is just the slide that I spoke of earlier regarding the definition of the acts of infringement. This is something that you can read through on your own time. This is obviously not something that I'll ask in the examination, but it is good to familiarize yourself with what could be constituted as an act of infringement. Hi, Tato, yes.
A quick thing on importing. Yeah. There's been circumstances where at the border, the goods are said to be going to another country, but they're in fact meant for South Africa. Let's say it's a counterfeit goods of the infringing article. When will it be considered importing under the circumstances?
Well, look, if it's at the border going out of the country.
Because, for instance, if it's going to Botswana, it has to go through South Africa. So it's not legal.
Okay. Look, if it's just passing through the country, then it's not considered importing. And I think there is specific provision in the Act for that, actually. So if it is passing through the country, then it won't be considered an importation of that product. And I think the same would be applicable for vessels as well, where there's provision made for in the Act. You know, where a vessel is passing through the shores of the country. If there's alleged infringing product on there, it's not actually considered an infringement of the patent rights in South Africa. Okay.
But what do you do under the circumstances where, let's say, the address in the third-party country doesn't exist? So it's obviously intended to go missing in transit.
Yeah, look, well, then, I mean, that could probably be your defense and your argument that there was the intent to import into South Africa under the pretenses that it wasn't intended for South Africa. So I guess that's the argument that you would have to put forward to the court. Okay. Okay, then if we have a look at section 67, it states in the first section of 67 that a claim in respect of a patent for process or an apparatus for producing any product shall be construed as extending to such products when produced by the process or apparatus claim. So if the claimed subject matter of your patent is directed towards a process for manufacturing a product, for instance, or a process for manufacturing a pharmaceutical. So any method of manufacture or process that is the subject of the invention, that protection would then extend, or the patent protection would then extend to the product of that process itself. So if you claim a method of manufacturing aspirin, but you don't actually claim the aspirin itself in your invention, the protection afforded to the patentee will automatically extend to the aspirin itself. Okay. So if we go through that again, it says a claim in respect of a patent for a process or an apparatus for producing any product shall be construed as extending to such product when produced by the process or apparatus claim. Okay, so there's not really much more than I can say to that. It's quite a straightforward provision. So as just to reaffirm it, it's if there's a claim to the method of manufacture or the method of production, that protection of the patent will extend to the article itself that is manufactured by that process. Then subsection 2, if the invention for which a patent is granted is a process for obtaining a new product, the same product produced by a person other than the proprietor of the patent or a licensee under that patent shall, unless the contrary is proved, be deemed in proceedings to have been obtained by that process. So basically the opposite of subsection 1. If there is another party that is manufacturing the same article, which is the subject of the patent or the process of that patent, then it is deemed that the third party's method of manufacture will be the same as that of the patentees, unless they can prove to the contrary. Okay, if we have a look at subsection 3, in considering whether any person has discharged the onus imposed upon him by subsection 2, so referring to subsection 2 over here. So if there is a trade secret, for instance, the commissioner shall not require him to disclose any secret process used by him in producing the product concerned if it appears to the commissioner that it will be unreasonable to do so. Okay, so the commissioner has to have consideration for any trade secrets that the third party might have, and not forcing them to disclose it unless it is absolutely necessary for them to do so. Again, not something that we're really going to touch on, but you should know that contributory infringement does form part of South African patent law in respect of patents, even though there's no specific provision in the Patents Act. It was held in the Grand Parois versus Sasol case that contributory infringement is part of South African law, and it was again confirmed in the dynamic fluid control versus LW Tank Water Systems case. Just remember that contributory infringement is a form of delict, and therefore in order to prove that there was contributory infringement, the requirements for delict must be met. Okay, so what are the defenses that alleged infringer can present to the court? That's obviously they just do not agree and say that they do not infringe the patent, so there's a non-infringement of the patent, and they'll argue it on that basis. Then what is very commonly used is the invalidity of the patent. So that is where there's the counterclaim for the revocation of the patent, which again we have discussed. Where there's leave and license, so this is where there is an alleged grant of a license under the patent to the alleged infringer. They can argue that, well, I was granted a license from the patentee, and again for the courts to assess whether that is the case or not. And also that the rights of the patentee have been exhausted is also possible to be used as a defense. Okay. Very importantly, the ignorance of the existence of a patent is no defense, similar with the general laws, principles of law. If you're not aware of that law, doesn't mean you're not guilty of committing an offense. So the ignorance of the existence of a patent cannot be used as a defense. If we then turn to the remedies that the patentee can pursue in an infringement action, this is provided for in section 65. So a plaintiff in the proceedings for infringement shall be entitled to relief by way of an interdict. So the court can grant the patentee an interdict to prevent anyone from committing any of the acts of infringement. They can also deliver up any of the infringing products or any article or product which that patent form or that product of the patent forms an inseparable part of. So if only, if we look at the dependent patent, if the chip is an infringing article, then the whole phone would have to be given up because it's inseparable from the phone, and it would have to be delivered up. Then also an award for damages. You can have a look at section 66 that deals with the restrictions on the recovery of damages for the infringement. It's a bit beyond scope of what's required for this subject. The patentee can also pray for in lieu of damages, that an amount calculated on the basis of a reasonable royalty be awarded to the patentee as a remedy. So the court will then actually have to assess, had a license been granted, what would the royalties have been in respect of, of the act of infringement over that patent, had there been a license. So in lieu of damages, he can be awarded that amount based on a reasonable royalty in respect of that patent. Also, don't forget to pray for your costs order in your application to the court. And something, again, that we have reiterated at length is that there is specific provision that the defendant can counterclaim for the revocation of the patent during the course of infringement proceedings. Okay, if we then have a look at section 68, this is in instances where relief is sought for partial validity. So if one of your claims is novel and other claims are not said to be novel, then it is only partially valid. And this is applicable in those instances where not all of your claims are said to be novel and inventive or industrially applicable. So where any proceedings for infringement of a patent, the Commissioner finds that any claim in the complete specification in respect of which infringement is alleged is valid, but that any other claim therein is invalid. So in other words, where a patent has at least one valid and one invalid claim, the following provision shall apply. Okay, so namely, if there is a counterclaim for revocation on the ground of the invalidity, the Commissioner may postpone the operation of any order issued thereon, as may be required to enable the patentee to effect any amendment of the specification. So the Commissioner can stay the proceedings and then allow the patentee the opportunity to amend the patent to bring it into a valid and enforceable form. Do you follow with what's going on here? So if one claim is valid and other claims are said to be invalid, and if the defense is based on the ground of revocation where it is said that the patent is invalid, then the patentee is entitled to first remedy the patent to bring it into a completely valid form and to be able to enforce it then rightfully so. But in that instance where the patentee does amend the specification and the claims to bring it into a valid form, then the Court of the Commission of Patents can order the costs as he may issue, and as to claim from the date from which damages shall be calculated, grant relief in respect of any claim which had before the amendment been found to be valid and infringed. So the courts can then effect an order only relating to the claims that were valid at the time of the infringement. Again, an assessment that the Commission of Patents would have to make. So it only needs to grant relief in respect of the claim which had been found to be valid and infringed. Okay, if we then look at the declarations regarding non-infringement, this is something that you can work through in your own time again. This is basically that you can approach the Court for the Commission of Patents to issue you with a declaration that the act that you are committing does not infringe any existing patent or the patent that is in dispute, and be awarded with such a declaration by the court. In Tato, you briefly mentioned the BOLOP provisions yesterday. This is provided for in section 69A, and these are the exceptions to infringement where an otherwise act would be considered an act of infringement. This was introduced into the act as what is commonly known as a BOLOP provision. And is mostly applicable to the generic pharmaceutical manufacturers. So if we have a look at the first subsection, it says, it shall not be an act of infringement of the patent to make, use, exercise, offer to dispose of, or import the patented invention on a non-commercial scale and solely for the purposes reasonably related to the obtaining, development, and submission of information required any law that regulates the manufacture, production, distribution, use, or sale of any product. And as I said, this is most applicable to generic pharmaceuticals. So where you are allowed to import, for instance, the patented article without the consent of the proprietor, provided that you're not importing it for commercial benefit, but solely to obtain market approval or the necessary regulatory approval to enter into the market once the patent expires. So this just allows the generic pharmaceutical manufacturers to be able to enter the market as quickly as possible as soon as the patent expires. So that they don't need to wait until the expiry of the patent to obtain all the necessary approval in terms of any other statutory requirements to enter the market. Okay. So they can make use of that patent in order to obtain whatever approval is required to enter into the market once the patent expires. Okay, so this is to assist with the access to medicine for the public. Then have a look at subsection 2. It shall not be permitted to possess the patented invention made, used, imported, or acquired in terms of subsection 1 for any other purpose than for obtaining, development, or submission of information as contemplated. So this basically reiterates that you can only commit one of these alleged acts of infringement, were it actually an infringement, only for market regulatory approval. So you cannot import all these articles that are patented, for instance, and then stockpile it so that you can sell it out of your own accord once the patent expires. So this relates mostly to stockpiling, where you use or manufacture an article or import it so that you can then sell it once the patent expires. So that's not permissible. It's only in order to obtain market or regulatory approval to enter the market that you wouldn't commit an act of infringement. Everyone happy with that? Any questions? Yeah, nearly there. Okay, something else that I do want to bring to your attention is section 71, which is a remedy for groundless threats of infringement. So this provision provides that you cannot make unjustified threats of infringement as a patentee to a third party. So if we read through the section, it says where any person by circular advertisement or otherwise threatens any other person with proceedings for infringement of a patent, a person aggrieved thereby, whether the person making the threats is or is not entitled to or interested in a patent or an application for a patent, institutes against him and obtain. So this is now the party that's receiving these unjustified threats of infringement. They can approach the court of the Commission of Patents to obtain a declaration to the effect that these threats are unjustified. They can also obtain an interdict stopping the patentee from unjustifiably threatening infringement, and they may also obtain an order to recover any damages if these are sustained. Okay, unless the person making the threats proves that the acts in respect of which the proceedings are threatened constitutes, if done, would constitute an infringement of a patent. So you have to be very wary in threatening another party with infringement proceedings as a patentee, because again, it can land you in hot water if those threats are unjustifiable. And this does often happen in practice. A lot of people believe they have a patent and that their patent includes everything between the moon and the stars as a subject for their monopoly. And unfortunately, that's not the case in reality. And they will then unjustifiably threaten people with legal action for infringement proceedings. So you have to be very wary when you do approach a third party in circumstances where you suspect there might be an infringement. So be very wary in practice to send a letter of demand or a letter threatening infringement proceedings to another party. What you would do is rather write a letter of demand, bringing another party's attention to the patentee's rights. So writing a letter to party A saying, party A, my client ABC is the proprietor of this patent, a copy of which is attached for your records, so that you then place them in mora, that they are aware of these patent rights, so that you can take action at a later stage and recover damages if you do pursue infringement proceedings. But if it is an unjustified threat, then that party that is threatened does have recourse to the court to obtain a declaration or an interdict or damages if any damages are sustained. Okay, so be wary of this in practice when bringing proceedings to another party. Okay, this again is for self-study. You can have a look at different evidence that can be brought before the court. This is dealt with from section 72 to 74, not something that we'll be looking at. Again, appeals to the commissioner and the court. We're leaving this for self-study as well. Very straightforward. It just says that any decision made by the register can be taken on review to the Commission of Patents and so forth. A lot of you should be familiar with these types of provisions in any event. Again, all self-study, similar with offences and penalties, not something that I will examine you on. So you can leave out offences and penalties from the study material, but please do familiarize yourself with the different offences and penalties. This is in the case of you bribing a patent office official, for instance, if you incorrectly cite the patent office and make improper use of the patent office's description. I'm trying to think of a few more. If you allege that your article is patented when it is not patented, those are one of the offences that will fall within this ambit, and then the penalties in respect of that. Okay, so all of this for self-study, for self-interest. Any questions? Can we go home? Is that the question everyone's asking? Well, I think most of you are at home, fortunately. Okay, no questions, everybody, because that brings us to the end of our workshop. No? Okay, everyone happy. Right, so if there are no questions, a very big thank you from me for your attendance, for enduring with me. I hope that I have imparted some of my knowledge onto you, that some of my enthusiasm has been passed on to you as well. Like I said, I wish you all the very best in the preparation for the upcoming exam. Just to confirm, I believe the date is the 28th of June for South African Patent Law and Practice. Please don't take the amount of subject matter lightly. It is a lot to take in. The exam isn't easy itself, so be well prepared for the exam. Please do work through past papers as well, and come prepared to our question and answer session. I will set a suitable date about a week or two prior to the exam, just to give everyone an opportunity again to ask any questions if they wish me to reiterate something, and then to work through 2 past examination papers with you. Okay, so thank you very much, everyone. Have a fantastic weekend. Get some rest before all the studying starts, and take care. Thank you.
Thank you, Marco.
Pleasure. Thank you.
Thank you.
Thank you.
Yes.
Thank you. Thank you.
Thank you.
Thank you,
Thanks a lot.
Michael.
Thanks.
Thank you. Goodbye.
Bye-bye. Thank you.
Bye.